are in agreement that the claimant was employed since 1st of March 2003 and that he eventually rose to the rank of Manager Logistics Department, handling all transportation/haulage of the defendant products. And on the 31st of May 2017, a full truckload of goods of the defendant got missing after it was consigned to one company known as Ade Difa Enterprises, a company wholly owned by the defendant. Claimant later agreed that the goods were entrusted to another company hired by his own company, Ade Difa, without necessary checks or use of the search engines as provided by the claimant to ensure that all the trucks brought to truck its goods are thoroughly inspected before goods are consigned to them, as he was wont to do. So in a turn of events, Amonak, that's the company that was later found to be non-existent, never arrived Kano State, the agreed point of delivery. Thereafter, the case of the defendant is that the claimant grossly neglected to take all the necessary safety measures, for which the defendant lost a total of 8,000 cartons of his product worth 16 million naira. He was then asked to proceed on indefinite suspension. Claimant's company, Ade Difa Enterprises, wrote to the defendant admitting the loss of the defendant's goods, and he prayed to be given time to sort the matter. The police took him to court, but he was discharged and acquitted by the advice of the Lagos DPP. He was not reabsorbed because the defendant is of the position that the DPP's advice was not acquittal, and it was not aware that the claimant had been so absorbed until he received the letter of claim from the claimant's solicitor demanding several claims purporting to be his right, arising as consequential to the purported acquittal. Furthermore, the defendant stated that the matter is also pending at the Lagos State High Court at its instance for the losses it took on account of the greed and avarice of the herein claimant, and as such cannot make a counter-claim, as that would amount to an abuse of court process. The claimant tendered 5 numbered documents at exhibit, and they were marked and they were admitted and marked as exhibit D1 to D5. I will not go into the defendant's final written address. I have it all in the body of the document. And I also have the claimant's final written address and issues for determination. So I'll go straight to the court's decision. Okay. I've carefully considered the originating processes, the evidence, the submission of counsel, and authorities relied on in the final addresses. This case shall, however, be determined based on the relief sought, seriatim. The claimant is seeking for a declaration that, having been discharged and acquitted by a court of competent jurisdiction of the infractions alleged by the defendant, he is entitled to payment of his lost salaries, benefits, and other emoluments from the defendant from June 2017 till date. Declaratory reliefs are not granted as a matter of course, not even on an admission by the other party. In Oguntade versus Oyela King, citation provided, the Supreme Court held that the appellant must pass the acid test of succeeding on the strength of his own case and not on the weakness of the respondent's case. Oluchem versus Goody, Diaza versus Bangbose, Eya versus Olapade, citations all provided. In addition, the party seeking a declaratory relief must adduce cogent and credible evidence that is entitled to those reliefs. In proof of this relief, the claimant tendered his appointment letter of 1st March 2003, Exhibit C1, and promotion letter Exhibit C2 and promotion letters Exhibit C2 and C3. He further tendered his letter of indefinite suspension, Exhibit C8, dated 3rd July 2017, effective the same date. The suspension was without pay, following a former reported case of missing truck loaded with company products. The suspension was to allow for further investigation of the matter. The claimant tendered the legal advice dated 27th of November 2019 from the DPP of Lagos State that the claimant, and I quote, the other suspects should be discharged and released if still in custody, as there is no evidence to sustain any offense against neither of them, end of quotation. The magistrate court on the 10th of December 2019, which is Exhibit C10, gave an order that the claimant had no case to answer and he was discharged. It is part of our criminal justice system that the DPP is the office charged with the prosecution of criminal offenses. The primary function of the directorate, amongst others, are issuance of legal advice on case files sent by the police and instituting persecution against defendants. In Cole Oso versus Chelarams and Son citation provided, the court held that since the plaintiff was discharged, he could not be said to have committed the offense. In the instance case, the claimant has been able to establish through Exhibit C9 and C10 that he was discharged and acquitted by the magistrate court. a court of competent jurisdiction of the infractions alleged by the defendant, I so find. The second arm of the declaration is that he is entitled to payment of his lost salaries, benefits, and other emoluments from the defendant from June 2017 till date. The payment of salary when an employee is undergoing disciplinary suspension depends on the contract between the parties, see Okunorem and UAC. The court recalls that Exhibit C8, which is a letter of indefinite suspension, was with effect from 3rd of July 2017. This was issued in compliance with the provisions of the Human Resource Policy, Exhibit C5, page 16, Article 22.5, which was incorporated into his contract of employment, and it reads thus, and I quote, "An employee placed on suspension shall, during the period of suspension, receive no salary, and upon determination of the case shall receive the outstanding salary should the case be decided in his favor. Where the employee is found guilty, he or she would be summarily dismissed." End of quotation. So by Exhibit C5, the HR policy, if the case is determined in his favor, as in the instant case it was determined in claimant's favor, he is entitled to a salary during the period of the suspension. The courts have also held that an employee is entitled to a salary during the period of suspension. See Yusuf versus Volkswagen of Nigeria Limited, citations all provided. So the claimant, having been discharged by the court order on 10th December 2019, he is therefore entitled to a salary from 3rd July 2017 to 10th of December 2019, which is the period of the suspension to the date of discharge. For the period after the court's discharge till date, and I quote, in quotation mark, the claimant during cross-examination testified that he did not write to the defendant company to inform them that he had been discharged by the magistrate court. He never presented himself at the workplace, and invariably he was never denied access. This declaration the claimant is seeking for, he has not been able to prove before this court that he is entitled to salaries, benefits, and other emoluments from the defendant from June 2017 till date. The claimant indeed has no evidence before this court that he attempted to present himself for work and was denied access to the workplace. Rather, in Exhibit C11 on 16th of September 2022, he wrote a letter to the defendant demanding for entitlement from June 2017 till date. The defendant company has stated that it was not aware of the discharge order because it was not in court on the date claimant was discharged, while the claimant maintains that the defendant should have followed up on the case. After all, it was defendant's report to the police that triggered the criminal charge. It has been held in a plethora of cases that equity refuses to help the indolent or lay about. See Wali versus APC, Habib Bank versus Ochete. Rather, in Ndume, local government councils versus Yaro, citations all provided, the Court of Appeal held that equity aids the vigilant and not assist an indolent party, as the appellants have shown themselves to be in the instant case. When a person sleeps on his right, it may turn out to be a costly or expensive sleep with irreversible consequences. This was a decision in Krotek versus Obeten, the Court of Appeal case. So in the instant case, the claimant who had risen through the ranks from a procurement officer to the position of a manager in the defendant company ought not to have neglected to report to duty immediately the court order discharging him was issued by the court. To stay away for 33 months outside his employment without making any effort to reconnect with the defendant company was unreasonable. A cursory look at the letter he eventually sent to the defendant company in 2022 was not a request to resume work, but a demand/notification for payment of his entitlement. It has earlier been established that equity helps the vigilant, not the indolent. The claimant cannot claim salaries for period he did not work. In the Supreme Court case of Skybank versus Adego, it was decided that an employee would only be paid for the period he served his employer. Hence, an employee cannot claim for salaries not earned. See also the decision in CCB versus Nwankwo, Balogin versus Union Bank, Olatuboso versus NISA Council. Citations all provided. So this court is therefore of the view that the claimant is not entitled to a declaration that is entitled to payment of his lost salaries, benefits, and other emoluments from the defendant from June 2017 till date. Relief 1 succeeds in part to the extent that this court makes a declaration that claimant is entitled to a salary during the period under suspension only. The second relief is for an order of the court directing the defendant to forthwith rescind and unlift the indefinite suspension placed on the claimant which is not in consonance and or contravenes clause 2.5 of the defendant's HR policy handbook. The law is settled that in the determination of employment rights, it is the employee who complains that his employment contract has been breached, that has the burden to place before the court the terms and conditions of his employment that provides for his rights and obligations, and the manner the said terms and conditions were breached. In proof of this relief, the claimant tendered Exhibit CA the letter of indefinite suspension dated and with effect from 3rd of July 2017. Also tendered is the HR policy Exhibit C5, which provides for suspension without pay, and further stipulated that upon determination of the case, a suspended employee shall receive the outstanding salary should the case be determined in his favor. Parties are in agreement that the claimant is still on suspension. Claimant has tendered the magistrate court order which discharged him of the offence and is therefore seeking that the indefinite suspension should be rescinded and or lifted as it contravenes the provisions of the HR policy. On the nature of employment, Sarah Joe JCA in Globe Motors Holdings Nigeria Limited versus Oyewole stated, and I quote, "It is clear that a suspension is not a dismissal which denies an employee his rights, salary inclusive. See also Nweke versus Unizik, Oka. Citations provided. Indefinite suspension is a disciplinary action taken by an employer without a definite or specific period of time. Nigerian courts generally frown upon indefinite suspensions. In Mobile Producing Nigeria Limited versus Effiong, citation provided, the Court of Appeal condemned indefinite suspension without pay as an unfair labor practice. In Akinyanju versus Unilorin, citations also provided, it held that the employee cannot be placed on indefinite suspension without due process or hearing. Also, in the case of Dangote Cement PLC versus Aga and another, citations provided, Ogunwumiji JSC also held that indefinite suspension without pay was wrongful. Therefore, the respondents were entitled only to their salaries and allowances from the date of their indefinite suspension to the date of the termination of the appointment. The defendant company has argued that the claimant is still under investigation and that there is a pending suit at the High Court. Therefore, it justified the indefinite suspension of the claimant. The defendant has argued in his final written address that the claimant's actions, including using his personal company to haul the defendant's goods without permission, making illicit profits, and neglecting his duty to verify transporters, constitute gross misconduct and a breach of the terms of the employment contract, which is Exhibit C5. Accordingly, the defendant submitted he was justified in disciplining him via indefinite suspension pending when the case at the High Court is determined. This court has noted earlier that there is a judicial clearance of all allegations against the claimant. The details and the relief sought at the High Court are unknown to this court, and what the defendant has left the court to do is to speculate. In Amasa and others versus the Chairman National Population Commission, Adumi and JCA held that the court of law cannot speculate on anything. See also a Kenta-based Nigeria Limited versus Attorney General of Rivers State and Ejezie versus Anuwu, citations all provided. In Akinyaju versus University of Lawrence Supra, the Supreme Court emphasized that even when an employee is suspended, the employer must either conclude investigation within a reasonable time or pay the employee during the period. Therefore, an employer cannot withhold wages indefinitely under the guise of suspension without concluding due process. The claimant's indefinite suspension is wrongful, and the defendant is to forthwith rescind and or lift the indefinite suspension placed on the claimant. Relief 2 succeeds. Relief 3 is seeking for an order of the court directing the defendant to pay forthwith the sum of 27,623,046.15 kobo as lost salaries, benefit, and other emoluments to the claimant covering the period from June 2017 to December 2022. This court had earlier reasoned and declared in Relief 1 that the claimant is only entitled to salaries during the period of his indefinite suspension, which came into effect on 3rd of July 2017, up till when he was discharged from the magistrate court on 10 December 2019. Beyond that period, this court declines to grant the entirety of the amount sought in Relief 3. I so hold. Relief 4 is for an order of the court directing the defendant to pay all the salaries, benefits, and other emoluments due to the claimant from January 23 until judgment in this suit. From the record of this court, the claimant filed his statement of fact on the 20th day of December 2022. He did not plead facts nor tender evidence to establish that he worked for the defendant for the period he claims, that is January 2023, until today, the 1st of July 2025. The law is on a firm pedestal that an employee cannot earn salary for work not done. The claimant, having failed to notify the defendant or present himself for work for about 33 months after he was discharged from the magistrate court, cannot claim salaries for the said period. This relief 4 accordingly fails. Relief 5 is for the interest on the entire sum claimed above at the rate of 25% from June 2017 till judgment, and thereafter at the rate of 10% till the full liquidation of the judgment sum. The claimant did not tell the court how it arrived at its calculation of 25% per annum from June 2017. Besides, the indefinite suspension was with effect from July 3rd, 2017. So is the claimant telling the court he did not receive his salary? The claimant cannot raise new issues that were never placed before the court. By the HR policy, wages will be paid in arrears once every calendar month. There's also no term in the claimant's contract that provided for 25% interest on sums entitled to by an employee. Post-judgment interests are otherwise known as discretionary interest. In Africa Prudential Registrars versus Macaulay, citation provided, it was held that the claim for prejudgment interest more often than not arises from the agreement of the parties, that is, from the contemplation of the parties. So it is required to be specifically pleaded and proved for a party to benefit from it. Post-judgment interest, on the other hand, need not be specifically claimed before it is awarded, since it is statutory and the courts are empowered to award it at its discretion based on the stipulated rates, and it need not be proven. OAN Overseas Agencies Nigeria Limited versus Brownwen Energy Trading Limited and Order 47 Rule 7 of the NICN Civil Procedure Rules 2017, in the light of the success of certain of the claimant's monetary claims, that is, Release 1, the court hereby awards 10% interest only on the sums until same is fully paid or liquidated. I so hold. On this note, Relief 5 is resolved partly in favor of the claimant. On the provisions of Order 55 Rule 1 of the NICN rules, the court is also empowered to order costs to parties at its discretion, as it states, and I quote, "In every suit, the cost of the whole suit and of each particular proceeding therein, and the cost of every proceeding in the court shall be at the discretion of the court as regards the person by whom they are to be paid. By the discretion of this court, I make no order as to cost." Relief 6 is a relief for the sum of 1 million naira as the cost of this suit, which is declined. As I said earlier, I make no order as to cost. So judgment is entered accordingly and it is signed. So this is the judgment of the court.
I want to thank my Lord for a well-considered judgment. I'm most grateful. I'm most grateful.
Very grateful for the judgment of the court. We shall take, we understand, we will take necessary steps. We're very grateful.
Your own evidence of letter in
It wasn't bad, except that interest. The only thing is interest. It says up to date. Okay, but up to the time they ought to have demanded refund. It should have been up to the time. So in my plan, it says I will go to appeal, because I'm sure that a couple of appeal grant that one. But it's not bad. It's not bad. I wasn't even. I was afraid he would grant all his praise.
It's okay.
It's a very good indeed for me.
Hello, good afternoon, sir. Are you talking to us, sir?
No, the court is finished. Drop so that